Hi, everybody. Can you hear me?
Hello, yes.
Yeah.
Yes, I can hear you.
Yeah. First of all, I would really like that everybody has the microphone muted. I will be now talking a little bit, and then I will leave the words to Johan. So welcome here. I'm Maite from Ignite Sweden, and this is our brand new program, the kickoff session of our brand new program for legal. I'm sorry, for startup, that we are doing together with Synch. I don't know if you have been part of other workshops and other activities that we have for startup apart from our matchmaking, but we are trying to give you more tools so that you can succeed even more in your collaborations. So before I introduce you to Johan Ragnar from Synch, I want to say a few things so you know exactly what's going to happen today. First of all, he's going to give the presentation. After the presentation, we will have a Q&A. So if you have any question, please, I ask you to make the questions after the presentation and in the chat, and I will be reading them out loud for Johan. And then afterwards, as you know, we have 12 spots for a legal session, a 1-hour legal session with one of their lawyers. So we will be putting the link to that in the chat at the very end of the presentation, at the very end of the session. So you will have to click, and you have to be a little bit fast to click and book one of those times. Okay, so Johan, are you there?
Yes, I am.
Great.
And I also have my colleague Matilda online.
Okay, welcome, Matilda.
There's two of us.
Okay, now it's all yours.
Okay, thank you. Welcome, everyone. Nice to see or hear everyone online here. My name is Johan Ragnar. I'm currently sitting in my basement at home due to the Corona times. And I'm a lawyer, advocate at Synch. We are based in Stockholm. We also have offices in Skåne, where I am situated, and in Copenhagen. We will start this session with telling a bit about Synch, so you know who you're dealing with later on when we're going to help you with your legal issues. And then we'll go through the different kind of contracts, standard agreements that we have drafted for the purposes of Ignite's program once you cooperate with larger companies. Then, as we heard, there will also be a Q&A session, so please feel free to ask questions in the chat, and we'll be happy to provide you. And don't forget to book the one-on-one sessions where you'll get unique and free legal advice for your company. Okay, so I'm going to share a screen with a presentation. There we go. Now I hope this is visible, or else let me know.
We see it in presenter mode, so we see the next picture and your notes.
Oh, okay. Yeah, that could be a problem with now. Is that better?
Yes.
Yep, great. Okay, so first of all, we really love startups and scale-up companies. We are very used to working with these kind of companies. We usually do this through collaborations with the hubs in Stockholm, Skåne, and Copenhagen. We have collaborations with about, I think, 7 or 8 organizations in Stockholm, and so far 2 or 3 in Skåne, and then a number of organizations in Copenhagen. But we're very used to working with startups. I believe we have around 500 or 600 registered startup scale-ups in our client database. And why do we love that? Well, it's very inspirational for us working with early stage companies. It's a lot of fun to take part of and being part of the great ideas that arise in Sweden and the future companies, so to say. And of course, we also have the legal competence to help all of you. Now, we are a business-oriented law firm with innovation and technology at our heart. And this means that to the largest extent, that our client database consists of companies which are innovative or working with technology. And it's everything from the small startup of 1 or 2 persons up to great listed companies on the Swedish stock market and everything in between. We currently have offices in Stockholm, and we have a presence in Skåne. Stockholm is, of course, the center of innovation in Sweden. If you see to the number of companies that are started, Skåne also has a great potential, as well as Gothenburg, of course. Then we have 20 colleagues in Copenhagen, situated in Hellerup, which are part of Synch, and we have a small representative office in Silicon Valley in the US in order to stay close to where it happens. All in all, we're about 50 people, including lawyers and administrative personnel. We're a value-driven organization, so this means that we have 4 values that we live by or live after, and the first one is transparency. We always want to be transparent to our customers and also internal. So we share a lot of information about what's going on within the firm, and our clients always receive. One example is that the invoice is specified down to the minute instead of just a 1-line invoice saying legal advice during July 2020 and then 20,000 kronor. So we want to keep a close dialogue with our clients. We're also curious in order to stay ahead, curious about our clients, curious about our colleagues, where we are, and we are friendly. Our ambition is to be the sort of soft and friendly law firm instead of the stiff upper lip 3-piece suit law firm. So hopefully you would perceive us as more relaxed and not so stiff. Our 4th and last value is harmony, and that's because we want to stay in harmony with our ever-changing environment. So legal services need to be adapted to our surroundings. We have a number of businesses that we work with. Venture capital is, of course, a business that you'll get in touch with or will eventually, hopefully. in order to gain capital. Then we have retail, including e-commerce, which kind of goes hand in hand into digital business, which is our largest segment. Industrial and resources is we have working with production companies making food. We also have some mining companies in our client database, and health and life science is of course a growing business with a lot of things going on. Now with the Corona focus, health and life science has really grown even more than before. And we work with growth, established and mature companies, where it's distributed. Around 40% of our clients are within the growth segment. And the same amount is within the mature, and whereas in the middle we have the established companies, and that's actually our smallest segment by 24%. We're a mid-sized firm, so you might expect that that would be our largest segment, but since we have focused a lot on growth companies, that is actually the largest one. So what makes us unique? Well, we have no partners, which is one of the few, perhaps the only business law firm in Sweden which is organized in such way. You might be familiar with law firms being usually organized as a triangle, where a number of partners in the top, and then you have a large base of associates in different levels, a very hierarchic organization. We have organized ourselves as a normal aktiebolag, limited company. So we have a board of directors, we have a management team, and then we have different positions which you can take. If you're interested in marketing, then you can focus on marketing. If you're interested in very interested in legal, hard legal issues, then you can sit at your desk and do research. Or in technology, you can be part of our digital business team, which delivers legal tech solutions. And we have launched 2 such products. One is available for free on our website, the AA Privacy Policy Check. That is a tool where you can paste your privacy policy, and through AI we have trained this tool to deliver a compliance checklist. Is your privacy policy compliant with the GDPR? Our second product is about data processing agreements. When another person or organization shall process your data, you need to enter into a written agreement, and that needs to follow a specific format. We have developed this product during 1 year together with a number of Swedish organizations, and launched it about 6 months ago. And it turns out that this reduces the lawyers' manual work with up to 75%. So this is a thing that the legal industry needs to keep up with technology, and Synch tries to stay ahead or take lead in that development. There are numbers of organizations that we have or had cooperations with. As you can see, some of the big tech hubs in Stockholm and Skåne, and also a number of other organizations. And this goes hand in hand with our interest for startups and scale-ups, of course, and technology innovation. Okay, so what I'm going to do now is run through a number of agreements that we have drafted specifically for this program. This is all of these agreements are useful when a smaller company enters into an agreement with a larger corporation. So you probably already encountered the non-disclosure agreement in certain forms. The NDA can be, as it's also called, or confidentiality agreement, can be entered into during different stages in your corporate life. But usually it's done when you're supposed to cooperate with another company, and you do not want that your information that you're sharing to leak or reach a third party which is outside this relationship. The one that we have drafted, the template, is mutual. So the startup shares certain information with the partner or the corporation, and the corporation shares certain information with the startup. So if you have an ID that you don't want it to be copied, then you can or you must enter into one of these agreements. And if anyone breaches the NDA, that would be, of course, a breach of agreement, and you can seek damages from the other party. You can also insert a clause which regulates liquidated damages. That means that you have a set amount which a party shall pay to the other party in case of breach, for example, 500,000 kronor or any other amount which seems appropriate considering the damage. However, that the liquidated damages should not be an obstacle for the damaged party to seek further damages. So it's just that this, so to say, automatically shall be paid automatically in the case of breach. We also have the proof of concept and license agreement. And this regulates the incorporation of one of the parties' product with the other party's product in order for the parties to evaluate the viability of commercial application of the result of such joint efforts. So it could be the startup incorporating a product into the partners, or the other way around. And then the two parties evaluate how everything has gone along. And when the product is finished, the agreement expires unless it is terminated earlier. And the intention is to allow for the parties at the end of the agreement to either stop cooperating in the matter or enter into an agreement for a longer term, and in order to start a commercial cooperation. The third and fourth, actually, agreement or draft template that we have made is the product patent and software license agreement. And there are two variations here. The first one is only a patent license agreement. However, it could also include a software in order to work with a product, and therefore you need to add the software license agreement on top of the product patent agreement. So the startup company has a product patent. It wishes to license this to the partner. The partner will then produce and distribute products to customers, and the customers are the end users in this picture. And as I said, they may choose to include software created by the startup as part of this deal. So there are two templates, one including software and one that does not. And if a software is included in this deal, the partner is granted a limited license to use the software for the production and marketing of the product, and agrees to ensure that the end users enter into an end user license agreement, which is named an EULA at the bottom of this picture. So for this purpose, the EULA has been attached to the product patent and software license agreement in our template. So the licensee distributes the software, then ensures that the end users enter into the EULA and manages payments from the end users to the startup for the software. It might seem a bit complicated here, but I think once you follow the arrows and see the template agreement, it should be quite clear. So we also have the software license agreement, and if you have a software and you would like to license that to the end user directly, you can use this template. This doesn't involve any partner at all. It's just if you have your software, your product all set, and then would like to launch it, then you can use the template end user or software license agreement as a template. Now, those were the template agreements that we have, and they should be accessible in the Ignite database, I believe. Correct me if I'm wrong there.
Yes, exactly. They are actually available at our platform Ignite Magic, all of these. And they are, if you go to, oh, I will write on the chat. I don't remember. I think it's resources. Maybe Michelle can tell me better, but I think they are, all of these are in resources, isn't it? Yeah, she's saying yes, exactly. You have to log into Ignite Magic and then go to resources and you will find them.
Mm-hmm. Excellent. Now for some tips and tricks from us to you, from a legal perspective, that is. Number one, select the right business structure. In most cases, it will be, if the company is incorporated in Sweden, it will be an aktiebolag, because that's the most tax favorable. And also you do have the limited liability benefit. So if the company goes bust, then you will not be liable for any, not personally liable for any of its debts, with some exceptions. But if you've played it right, then it's the company that loses the money and not you as a person. You should always enter into written agreements. If you do business with friends and families, you might think that it's sufficient to just have an oral agreement. And oral agreements are in fact as valid as a written agreements. However, it's very hard to prove in the event of a dispute in a court who had said what you need witnesses and statements from yourself. The other party may have better proof. So a written agreement is always recommended in the event of important agreements. This includes the shareholder agreement. If you're many parties or more than one owning a limited liability company, I'm sure some of you already have this in your companies. It regulates who should do what in the company, what happens if a buyer approaches the company, should you be obligated to sell? What about if a shareholder wants to sell his or her shares? There's usually a preemption right, meaning that the existing owners have the first right to buy the shares prior to selling to a third party. So the shareholder agreement is always recommended. The same thing there, as long as everything goes well in the company, you might not in fact need it. However, if something happens or you become, well, not enemies, but you want to file for divorce, so to say, from each other, then this is already, most things are already regulated in the shareholders agreement. So please ensure you have that. You should also ensure to have insurance coverage, because if something happens, someone sues you, something happens with a delivery, goods disappear, or you have burglars coming into your office, taking your computers, your software, your data, and everything, the insurance will of course step in and take care of that. So it's well worth it. Also, know your tax obligations. Tax is, well, Synch, we don't work with tax. We have, however, friends who do, so we can recommend a good firm. We usually work with the Skeppsbron Skatt in Stockholm and in Skåne. Because tax can be quite burdensome, of course, and if you play it right, you can it can be quite favorable. Also, this also goes for or includes VAT, which can make a large difference if you have to pay 25% VAT or not. That could be actually the thing that determines whether you're going to be profitable or not. Also, ensure that your operations are legal from every perspective. Do you need any licenses? Me, myself, I work a lot with financial services companies, fintech, and these companies almost always need a license in order to operate correctly, or else the Swedish Financial Services Authority will fine them or file them, have them quit with the operations. This also includes the GDPR regulations, so that you treat your personal data correctly. And if you share it with other parties, you should also ensure that you have written agreements in place. So all kinds of licenses, and also, of course, make sure that you operate in accordance with the mandatory legal regulations. Number 6 is that you should protect your intellectual property. So if you have a trademark, for example, you should ensure to register that, or if you have a unique product which is patentable, you should file for a patent. Or if you have a written material that is protected by copyright. And this is, of course, so that no other company comes and steal your ID or your property and start a competitive business. Number 7 is actually true, not only because we're lawyers, but it is that you need legal help sooner than you think. And it's better to take legal advice from the start than having to deal with it afterwards. And that goes for all of the above. So getting help with written agreements, perhaps not insurance coverage, because the insurance companies will help you with that. Of course, ensure your operations are legal and protection of intellectual property. Also setting up the right business structure from the beginning, instead of having to, in case it's not the best one for your company, you need to break it up and do it all over again. So it's always good to get legal help. And this is why we encourage you to book these one-on-one meetings, because this is an opportunity where you can describe your business, and me and my colleagues are able to get you thinking about the initial issues that might arise when it comes to legal issues. Okay, the session is booked for an hour and a half, but this is actually what I had planned to tell you. So I'm, unless Matilda has something to add here, just gonna check with her.
Yeah, sure. Can you hear me?
Mm-hmm.
No, I think that perhaps there are questions now so that we can open up for that.
Yeah, exactly. I was going to say, if you have any questions, now is the time to make them. I will say them out loud to Johan and to Matilda, if you also want to answer a few of them. And remember that after the questions, we will be sharing a Doodle link to the to book this meeting. Plus, that I have just written on the tab exactly where on our platform Ignite Magic you will find this template. Okay, now comes the first question. How much experience do you have in working with GDPR and municipalities and regions?
In GDPR in general is we have several colleagues who work exclusively with that, I would say, only with that. So that is a topic that is dealt with daily at the firm. So a lot of experience. And then also we have our two AI tools that I introduced in the beginning. Which have been developed in-house by, we have a civil engineer who is heading this group, and a colleague who is both a developer and a lawyer. And then also with input from lawyers who are professional within GDPR. So that's, core subject at the firm.
Okay, the next one, we have got many questions now.
Good.
So the next one, it would be nice if you can give an indication of your hourly rate. I don't know if maybe that's something to discuss during the meeting, isn't it?
Yes, it is. But one of the things that differ us from other law firms is that we work a lot with fixed prices depending on the matter, especially in relation to startups and scale-ups. So that makes makes the matter predictable, both for us and the client. And as mentioned also before, you get a full specification of all the hours spent. But when we work with startup scale-ups, we always take into consideration that they could be bootstrapped, or there's not a lot of money to spend on legal fees. However, you need a lot of legal advice. As I said, you need it quicker than you think.
Yeah, exactly.
So that's the long answer. But I mean, our normal rates are between I think 1,100 and to up to 4,000 an hour. But that's yeah, that's just like an indication. So
yeah,
I wouldn't say it doesn't really matter, but in this case, you always get an estimate fee when you ask for our help, and then you can decide whether you want to work with us or not.
Yeah. Okay. Now comes the next question. I always charge VAT to my Asian and American customers. What is it with VAT outside the European Union?
Oh, that is a good question regarding tax that we actually don't advise on. I mean, if to provide an answer to that, and I will not guess, but this we could definitely refer to one of our friends at a tax firm instead.
Yeah. Maybe the person can send you a message to you through the chat, so you get the email address or something.
Exactly. So if it's Michael,
exactly,
send me an email, and I can refer you to any of our colleagues.
Well, now comes the next question. Do you recommend to get a patent to each software?
That's a very good question. A patent for software is per se not, it's not always possible actually to get a patent, and to say that to recommend whether or not to patent at all is also highly dependent on the type of invention behind the software, and also there a lot of costs comes with patenting products, so that should be taken into consideration. If it's possible to keep the invention as a secret within the company, if let's say that the invention is not revealed when the software is used, then perhaps it's better. Sometimes it's better to keep it as a secret, and then you can make money out of it, regardless of I mean, for more than 20 years, which is the exclusive period for a patent. So it's difficult to say, to give an advice on that without knowing more details. But this is definitely something that we could discuss on a one-to-one meeting. But it should also be stressed that in respect of patenting products, this is also something that needs to be discussed with a patent agent, someone that is technically a technical knowledge, and know something that we also have colleagues in the city that we work with, but this is normally not a lawyer that advises on the technical field.
Okay, the next question. Do you work with import-export agreements and agreements with potential customers, for example, that would include an NDA? I don't know if, yeah.
Yes. I'm not quite following the question, but import-export, that would actually be a sale or purchase agreement of goods. So definitely, yes, we do work with those. And NDA, sure. I mean, that would be included in the agreement. I assume that this means that there should be confidentiality obligations in regard of the goods that are being imported and exported.
Well, now this is not a question, but I will read it out loud anyway. Thank you for a great presentation. I realize that my company needs many of the things mentioned. So stay tuned when we share the doodle link so you have time to book your one-on-one meeting, isn't it?
Yes, it's a great opportunity to discuss all those things needed.
Yeah. Another thank you very much for a good presentation. I wonder if Synch helps with startup evaluation and due diligence.
Yes, good question. We have a standard product called oh, I've lost it, Matilda.
Well, yeah, actually, the name, but I forgot that as well. But
yes, early stage review. Yeah, that's the name. Early stage review, and it's like a small due diligence, you can say. So, and as the name implies, it's a legal review of the company, where we go through the agreements the company has. It's just to ensure that everything is all right. So it's on a red flag level. So we can warn the company, or so to say, or provide advice that this is missing, or you need to do this, you need to do that. And when it comes to the valuation, that's included in the price. However, we have outsourced that part because we are not accountants to an accountancy firm, and they do the valuation of the company. So everything is included, and you get it delivered as one package for a fixed price.
The next one. Thank you for all of your answers. When you license the patent, do we need the patent to transfer to the company? Currently, the patent is only under my name.
Well, if the patent is registered on an individual, in order for the company to make use of the invention, there should be a license agreement. And if the individual and the company is basically the same, the company consists of only one person, then perhaps it's not a big issue. But if you want to attract investors, then an investor will probably require a transfer of the patent rights from the individual to the company in order to want to make any investments. Otherwise, the license could be, depending on how it's written, of course, but there is always a risk that the license is withdrawn, and then the company, if that's what the company is doing, then the company is not worth much. So investors usually require patent transfer.
The next one. Do you have any? Go on. Sorry.
No. I was done. Yeah.
Do you have any tips on how to handle trade secrets and mitigate reverse engineering. Our innovation is basically nanoparticles. Some aspects are protected through patent application, but some maybe not.
Yeah, really good question. How to protect that, and quite difficult to give an advice on at this stage, but obviously a good start in order to keep something a secret is to have really strict guidelines and on how the company is sharing these secrets within the company and with potential third parties. I mean, I guess this still the best example is the Coca-Cola recipe that, as far as I know, still is not out there. And I think that their recipe on how they have done it is that no one actually has access to the whole recipe. So I mean, but of course, I guess you don't do what do you say? Well, Coke or something like that. So it's a totally different area, but still, really narrow access for a larger group within the company is probably a very good idea. If anyone shall have a full access at all. But of course, it depends on what type of product and secret we are talking about.
Okay, the next question. How much experience do you have on global structures, initially setting up business in Rwanda and Uganda, choosing between branch, subsidiary, and service unit, and the tax considerations that come with it?
Yeah. Well, when it comes to any international relations, we are Swedish lawyers, obviously, so we work with Swedish law. However, we have an extensive network of colleagues almost all over the world. So in this case, we would liaise with a lawyer in Rwanda or Uganda, and then ask them what would be the best sort of cooperation to set up in the country. And same goes with tax. So we will act as coordinator in such or lead counsel, as we say in the legal business, and then also liaise with these foreign lawyers.
Next question. Do you have any advice regarding setting up exclusivity agreements with larger companies? Any pitfalls or prior experience?
I can just start, and then Matilda can take over. Well, the exclusivity agreement is, of course, the big pitfall is that you're not allowed to enter into agreements with any other companies. So you're sort of stuck with that company. So if that company, if the cooperation doesn't work out really well, then it would be better to have a non-exclusive agreement. Then also, if possible, it would be better to have them as a preferred partner. So you can also, which means that you yourself may also produce or use or license the relevant product.
Another thing that sometimes solves the problems with the exclusivity is that you require the larger company, in this case, to buy like certain minimum amounts, and if they don't do that, and that's, of course, you have calculated that this is a good amount also for the startup company. And if they are not meeting these minimum amounts, then the exclusivity agreement will be turned into a non-exclusive agreement, which means that you are able to also enter into other license agreements within the same area. So that's I mean, one way of mitigate the risk of being stuck with only one player and the player doesn't play well.
Next question.
Mm-hmm.
Is there a guide to follow to protect our intellectual property, stuff that are simpler than software, like designs and content, so we'd be able to get compensated in case of other companies copying our content? This is something quite usual nowadays, unfortunately, isn't it?
Well, yeah, IP protection, I mean, is a really good thing. And so stuff that are simpler than software, like designs, there is within the EU a good design protection, which also definitely just protect the design of a product, or and that's I would say I don't know if cheap is the right description, but it's it doesn't cost you that much, but it gives you exclusive right to the design, and it's quite useful if you want to I mean, take actions against third parties that are copying you. There are some, I mean, I would be happy to have an additional discussion with Mina regarding this. I mean, there are some limitations as well, but and I don't think that, I mean, IP protection is good, but it's in order to, I mean, to be the only one using a certain design or invention or whatever, but it's difficult to say that you should protect in order to receive compensation from third parties. At least that shouldn't be the idea of protecting it, because you will never get more. You will never receive a higher compensation than the loss that you have suffered. So there is no punitive damages that are, for example, available in the US in some cases. I mean, that you are really punished for breaching the law, but that's not the case in Sweden, or as far as I know, and not in most EU countries when it comes to IP. But I would be very happy to discuss that further in a one-on-one meeting.
Yeah. I have a question that I think that we have already answered, but I say it because maybe you have something to add. Your advices are very relevant, but usually law firms charge so much that startups do not afford. Do you have any package for startups, such as, say, after fundraising or legal services for equity?
Well, yeah, as previously mentioned, we have certain fixed prices, and also consider that it's a startup being a client. But in addition to that, we can also defer the invoice, however, not forever, because we also need liquidity, believe it or not. And we cannot take equity as payment because we are an advokatfirma. So we run under the ethical rules of the Swedish Bar Association, which does not those rules do not allow us to take payment in any other format than cash. So I know there are some law firms that do take equity as a payment, but those are not members of the Bar Association, so they're not advokatfirma.
Next question. Should a fixed liquidated damage sum be in the NDA? And which sum do you recommend to work with large corporations?
Yes, that makes it easier, as mentioned during the NDA presentation. So we recommend to have a liquidated damage sum. However, with the addition that this does not prevent the damaged party to seek further damages in court or otherwise. And the sum, well, that depends on it should be, a general rule is that it should be a bit above the actual damage. So it should hurt for the person paying the damages. And it's hard to say like a general number applicable for all situations. That's shall be determined on a case-by-case basis. But,
yeah. It could be added that when you have these discussions with large corporations, it may not always be possible to include this. I mean, you can always try, but I mean, there are companies that would never sign that type of agreement. That could be good to have in mind as well.
Now, a slightly different question. What's your opinion on law as a service firms such as Pocket Law for startups? What do you think of them?
That's a great thing that complements our ambition to be the leading tech law firm in Sweden. Just a general advice is that with all standard products, you should be careful and really read through the result in order to ensure that the agreement or the document which is generated actually fits your specific situation. So it's a good thing to start with, but unless you're legally skilled yourself or feel comfortable with reading legal agreements, I would still, as a final thing, at least get a sanity check from a lawyer. But it's fun that these services are coming now.
I have a question now from someone that says that he is proactive and curious. You state that the legal is needed to be protected. What about the copyright for legal job that you get? And also, how is the lawyer insured if the advice generates problems for the customer in general? Does the insurance company cover a customer? Everybody does mistakes. A startup goes to the lawyer about their mistakes and their claims, but say something about the service delivery from a law firm to a company in general.
Yeah, good question. Yes, we are insured, definitely, by, I don't know up to which amount, but quite substantial amount. So our insurance covers damage which we may cause our client. So if a deal fails due to our mistakes or us drafting a lousy agreement or whatever, or missed a deadline or what it could be, then indeed the insurance company covers that. In addition, we have a reputational risk. We obviously sell trust. That's what we do. And if we fail too much or enormously, or it goes public that we have done a bad job, then we actually lose our right to exist. So it's kind of self-regulated in a way. We need to be professional in everything we do. But if something goes, I mean, sure, we're humans. Something could go wrong. We are insured. And copyright of legal job, well, you need to correct me. Matilda is the IPR expert here, not me. But I guess it needs to come up to vad heter det, verkshöjd, in order to get
originality. So
yeah, to originality in order to get copyright. I think that would be hard. And also, but another thing is that as a client, you have the client privilege that everything is confidential. So nothing that we produce will be shared with anyone else unless you allow us to. Not even the fact that you're a client.
I have another question here about the cost. How much is the cost of early stage review? Maybe that. Yeah.
Is it 35,000? I think. Not quite sure, but it's something in that region.
Exactly.
And then, yeah, go on.
So yeah,
Yep.
I think you're right about that, Johan. And I can't see the name of the person that wrote the question, but I mean, if you're interested, please send us an email, and we can give you more information on what is included in this early stage review and the price.
Yeah, or if you book a session, we can of course tell you more then.
Exactly.
Yeah. Now, new question. We are several in the team, and we would like to write an agreement on how to share the work activities, responsibilities, salaries, share. At this moment, we do not have any say. Do you think it is the best for a law firm to involve in the statement in such an agreement?
Yes. No, I'm just reading the question.
Yeah.
No. Well, this is usually if everyone here is shareholder, then that would usually be regulated in the shareholder agreement. But it could also be if everyone is in the board, it could be regulated in the rules for the members of the board, or just any document, any agreement is called, I don't know, distribution of work agreement or responsibility agreement, similar. But again, in order to make it right, if anything goes wrong, yes, we would recommend to have a lawyer draft that agreement.
We have one of the, yeah.
I had a question here sent to me privately, but I believe it's nothing private, so.
Yeah, go ahead.
Yeah, have you provided advice for agreements for SaaS service as a service in AWS or Azure Marketplace?
Oh, I cannot see you. Maybe we have. Are you there, Johan?
I'm here.
Yeah.
Hello.
Yeah.
Yeah, I don't know why.
I don't hear you.
Yeah.
You don't hear me?
Can everybody hear you, Johan?
No, I hear only Mite Bellon.
Does anybody else have the same problem? You can write on the chat. I can hear. Because sometimes, yeah, I can hear. Try speak a little bit more, Johan.
Yes. Okay, I'm trying. Can you hear me now?
Yes.
Good.
Yeah, great. Go ahead.
Yeah, I was thrown out. I don't know why. Speaking too much. Now, AWS, did you work with those agreements, Matilda?
No.
But in general, software as a service is, we work a lot with those agreements. And however, not me personally, but I'm sure that the colleagues have. So, well, the answer would be yes, we have worked with that.
Okay, so this is the last question in the chat. So if another one has a question, you have to be quick. Otherwise, we jump into sharing the link and stuff. I assume the teacher exception rule in Sweden still solid. Any comments?
Yeah. And with that, I assume that the person means that material or content created by the teacher. I hope that this is what it means, at least. Belongs to the teacher. And that rule still applies, but I don't know if did it belong to any of the other questions that we discussed before.
It could have been, because I'm surprised so many questions we got today.
Yes, excellent.
Yeah, so maybe we can jump into the sessions. So before we share the link, I want to tell you a few things to take into account. These sessions are only 50 minutes. We are going to share the doodle. In this doodle, it's going to be shown like 1 hour, but they are actually 50 minutes. They will take place on the 2nd and 5th and the 11th of November. Johan, maybe you can tell us a little bit what kind of advice can they get during this meeting, or Matilda?
Well, any advice, I would say. Of course, about the template agreements that we have provided, if you have any plans to enter into such collaborations with corporations. Then also about, well, I would actually go to this slide. Hang on. Business structure, all kinds of written agreements. We'll jump 3 and 4, and number 5 with licenses, GDPR, protection of your intellectual property. There were a lot of questions today about that, so I'm sure that some companies would like to receive further advice in that respect. And number 7 just wraps it all up, that this is a great opportunity to get free legal advice, so just grab it. No obligations from our side so far.
Perhaps you have looked at the templates and you're trying to use it, or you don't understand a certain clause or something like that, or you are already in a negotiation with one of the larger companies, and you receive some feedback that you don't understand. And I mean, we are happy to discuss whatever you have on the table, actually. We'll do our best to see if we can solve anything during this, any of your questions during these sessions.
And we are generalists, so we know a little about everything, so to say. However, we do have our specialties. Matilda is the IPR and also disputes. Hopefully you don't have any questions about that yet. And I have within the financial regulations field and general commercial advice. But if you have a question and I am the lawyer sitting there about GDPR, then I will refer you to a colleague, or I will take the question back home and then revert to you through email or just a follow-up meeting through Teams or Zoom or something similar.
Okay, I have 3 things to say, which are also very important about the meeting. The first one is that we cannot change the time of the meeting. If by any chance you cannot make it to the time that you have booked, send us an email to me and to Michelle. Michelle, now you can share your email address so they know. So another startup can get that spot, but we cannot change the hours. And despite what it says, once you book, you will get a calendar invitation. And despite that it says Google Meet, the meetings will take place on Microsoft Teams. And Michelle, you will see that Michelle is there. Michelle is not going to be part of the meeting. No worries. It's just that it's something that Doodle does. And Synch will contact you to provide you with the name of the person that you will meet and the link and everything. And then we said many times that these meetings are free of charge for your startup. And that's because Vinnova is funding them. So Michelle will send you more information about that. You will probably have to find something, but she will tell you more. To the lucky 12 startups that will get those posts. And now, Michelle, are you ready to share the link?
Yes.
Yeah, go ahead. So we will leave the Zoom open a few minutes until we see that the places are taken. Can you follow that, Michelle? So we know when they are taken.
Yes, I can.
Yeah, and you are only allowed to choose one to select one of those spots. So you know. So think about it before you click. Well, and I want to say thank you to Johan and to Matilda. It was a great presentation and a great question and answer.
Thank you very much. It's just fun to be part of this.
Really good questions. Fun to hear that, to hear that you have legal issues.
I think
we can do something. That's good.
Yeah, I think there are many startups that need legal advice.